Well, Stewart, thanks for coming down. Appreciate it.
I'm delighted to be here.
We've got two juicy topics for you here to talk about. Software liability, which the government has been promoting in their plans, and then the SEC case against Solarwinds. And the reason why I wanted to have you down is I worry when security professionals pretend to be legal experts. And I'm seeing a lot of security professionals, and I fall into this, I do this sometimes too, you know, we sometimes have opinions, but they're based on what we think should happen or what's right. So I really wanted to have someone experienced with Washington law and law in general on the stage. Let's start with software liability.
Sure.
Product liability isn't new. It's existed for many decades, probably a century or more. Where does product liability usually start? Is it legislation? Is it executive orders? Is it court cases?
So it starts with people thinking about what should we do to make our products safe, but the liability part of it often comes out of litigation in front of courts. Judges look at accidents and say, you didn't do what most people are telling me should be done, and somebody got hurt, and I think that person should be compensated. And the courts got enthusiastic about that, I think probably in the 40s, when they realized that there was an economic justification for what they were doing. They were putting the responsibility for the losses on the party that was in the best position to prevent those losses. And that is the economic theory now for strict liability for products, is you designed the product so you could prevent the disaster in a way much better than your customers, and so we're gonna hold you responsible. Whether that will happen in the context of cybersecurity is less clear, partly because often the damages are not as obvious as you'd think. And they don't fall on individuals, but they fall on other companies, and those other companies then get a slightly less sympathetic hearing. And it's harder to identify exactly how much did it cost as a result of this. So I think it's been slow to emerge. Obviously, the courts are enthusiastic about software. They think technology has been good for the country. They don't want to impose liability that destroys innovation. That's also been a reason to be cautious about this. And there are, as we all know, we've all signed licenses. You know, you can't get through the day without agreeing to somebody's terms and services. And those terms and services are a contract, and they all say, hey, I'm not liable if this software causes you a problem. Courts enforce those rules sometimes, and they have enforced them in software, but they don't have to. And in the development of products liability for automobiles, say, or ordinary consumer products, the courts just waved that stuff away and said, well, you can't have a set of terms that are unacceptable to ordinary people or that are unfair. And they said, we think without liability, this would be unfair, and they just imposed it. So you can't count on terms and services and licenses to prevent liability from emerging, but the cautiousness about how this will actually affect innovation, I think, is a very real concern still.
It was interesting. You think then, for example, Clorox was a big case last year where they have numbers.
Right.
They said we lost 26% of our manufacturing capability or capacity. I think they put the cost at $47 million. It might be higher than that. I don't remember the number. But because they're a company, so if Clorox sued let's say it was it wasn't due to a product flaw in this case, but let's say it was due to a product flaw.
Right.
And Clorox said, we're going to sue you for this, we're going to take you to court for this. You think they'd have less chance of succeeding?
I think they would have less chance of succeeding, and they would be less likely to bring it, because most companies are also on the receiving end of exactly that kind of lawsuit. Like Clorox gets sued because, you know, the bleach caused problems for somebody, and so they're conflicted about taking products liability law and expanding it. And you know, if you're service provider, somebody who sold you code, has failed you and you have suffered a harm, there's a decent chance that you're bigger than your service provider and that they won't be able to carry your losses. And so bringing the lawsuit doesn't actually provide for a remedy that most companies are content with.
Well, you know, now this is me playing lawyer, but there was a case, McPherson versus Buick in 1960. I heard this on one of the legal podcasts, where a car manufacturer got sued because there was a defective wooden wheel.
Right.
And the car manufacturer said, well, I didn't make the wheel. And the judge said, well, that doesn't matter.
You sold the product.
So would that be comparable to like a Siemens, Emerson, Schneider Electric, a large company that's selling a system? If they get delivered some product, they could potentially be liable?
They've got a boatload of open source in there that they didn't write, and they can't be absolutely sure it doesn't have a problem in it. And we're already starting to see at the federal level with this software bill of materials, a determination to say, I don't care, you're responsible for that if you're selling it to me. And the effort to impose liability for supply chain failures is going to continue for years. We're going to see a lot of that.
Well, so that's judicial. Let's look at executive now. And this is where most of the action is.
Yep.
This is the National Cybersecurity Strategy really focused on this, that they want to push software liability on the people in a best position to affect it and pay for it. Can they do that?
So they can't do it without legislation if they want it to really stick, and they're not going to get legislation. So they can do it by indirection and what you might describe as body English. They can write regulations that say, we expect this. They can write regulations that say, we think these are things that any software provider ought to do. And they've done that. They've said there needs to be a software bill of materials. They have said you need to tell us more about your supply chain. And they are working to establish standards, and this is probably the most likely to be influential, about what cybersecurity needs to do. Because what the courts tend to do when they're making up new obligations is to say, we're going to impose the requirement that you act reasonably. What does a reasonable cybersecurity company provide? What kinds of cybersecurity are state-of-the-art and accepted in the industry? And to make that decision, they look to standards. And as we all say in the software industry, the nice thing about standards is there are so many to choose from. And what the administration is trying to do is to get standards out there, and then they will go to court and file amicus briefs saying, if they didn't meet our standard, then they should be held liable. That will be the most likely way in which they will get liability imposed. Whether that will carry through to the next administration, I think if it's a Republican administration, they are much less friendly to the plaintiff's bar and much less enthusiastic about creating liability. So this could be one of those, the many topics that flips back and forth from Republican to Democratic administrations. And so it's harder to persuade the courts to buy a legal theory that only one party endorses.
And I always wondered when I saw the strategy, two of the big pillars, or I don't think they were called them pillars, but the two big initiatives I saw were secure by default and software liability. And the way you describe that sounds to me like they're tied together. If you say this is what you should do, secure by default, then if you don't do that, that could be what's pointed to.
Some of the more interesting proposals for liability have had a kind of two-tier element, that there should be an element of stuff that any idiot should have done with their software. You know, if you didn't do this, you know, shame on you. If you just have a default passwords that can't be changed, you should be held liable, right? And things of that sort, where everybody would say, of course you should do that. And And that would be automatic liability, essentially. And then for the many other ways in which software can go bad when challenged by sophisticated attackers, the question would be not, did you make a mistake? Because obviously it's always a mistake at some level if somebody can get in. But did you follow proper code discipline, good procedures in deciding what code to deploy? And that is a procedural response, and the idea would be, yes, you can be sued for mistakes in your code, but if they aren't the kind of any idiot mistakes that were covered by the first tier, you have a defense of saying, yes, I made a mistake, but I was following a reasonable set of procedures designed to minimize mistakes, and I shouldn't be held liable if I've done that.
Okay, and then we didn't talk legislative, but I kind of heard you say not much of a chance of anything.
Not as long as there's a single Republican-controlled House of Congress. Yeah.
Okay, so if the House or Senate is Republican, you think that's
that would be my guess.
okay? Okay, let's. I know that maybe even the juicier topic is the Solarwinds case, because we have some CISOs in the audience and some public companies in the audience, so I'm sure they're anxious to hear about that. So SEC complaint against Solarwinds and their CISO, Tim Brown, who gave a presentation that went over very well. I think it was S4x24. I doubt we'll be seeing a lot of CISOs giving those presentations anymore, talking about what went wrong. But why don't, if you could, maybe give the facts of the case and, well, why don't you start there?
I'll start there. Okay. So, and we all kind of remember it, but Solarwinds makes a product that a lot of MSPs use for monitoring systems. So they're widely deployed by people who are providing security services. And the Chinese cyber espionage teams that want to break into systems figured out that if they could compromise Solarwinds, it gave them a leg up on compromising their real targets. So they could kind of do a bank shot to get into their more attractive targets. And in 2019, they started attacking Solarwinds, and they were able to get into Solarwinds. And in early 2020, they actually rewrote a piece of software for Solarwinds so that it had a built-in software flaw that they could exploit later. And it was deployed in February, I think, of 2020. And then Solarwinds started to see, first in the spring, they had one incident, and then in the fall, they had a second incident where customers were coming to them and saying, we've got this intrusion, and it's really bad, and it looks as though it's tied some way to SolarWinds' Orion product. And SolarWinds was slow to say, oh yeah, we screwed up there. They didn't find it, and they didn't admit that they had a problem until their third customer came to them and said in December, you wrote this code, and the code is bad, and it's allowed people to get into our network, and you need to disclose that. And SolarWinds disclosed it as part of a securities disclosure, an 8K, which is kind of an emergency disclosure, in December. The argument, after 3 years of investigation by the Securities and Exchange Commission, is should SolarWinds be held responsible for having failed to provide clear guidance about how bad its security was, and for failing to notify customers and investors after the first or the second incident. The SEC said yes to both of those questions, and it also said, to I think a lot of people's surprise, and Tim Brown, the effective CISO, should be held responsible for some of those errors. To my mind, most of that is wrong. The SEC's working very hard, and then they've just recently put out an amended complaint that is 150 pages of what they consider the evidence that justifies what they've done. And to my mind, it is particularly unfair to Tim Brown, probably unfair to Solarwinds, and I guess I would say, notwithstanding that, you all have to live with the fact that these guys have the authority to impose massive penalties on people, including CISOs, and telling them they'll never hold another position at a public company again. And so how do you protect yourself against that kind of dubious regulatory ruling? And we got to talk a little bit about that too.
Yeah, and so they came out with this complaint and this evidence, and then there was an amicus brief, kind of a friend of a court brief, I guess you'd call it, where a third party submits something for their consideration. You were one of the co-signers on that with Chris Inglis, Chris Krebs, J. Michael Daniel, Kemba Walden, Mark Weatherford, and people in this audience know Mark quite well, Mark Weatherford and others. So you signed that. But one of the things that was interesting is it really focused on how this case could disincentivize sharing cyber threat information.
Yeah.
And I'm having a little trouble understanding how you make that leap. How do you connect those two?
So this way, if you're going to do information sharing about an incident or about a concern, an intrusion, you're going to need to get a lot of information together, and you're probably going to ask the people who are dealing with the incident what they think is happening. They're going to give you answers, and those answers are sometimes going to be wrong because they will have guessed at what's going on, and it will turn out not.
But who's the you in this case? They're going to
You're the company.
Okay, so they're going to give the company.
You're the CISOs, you're the company, you're in an information sharing group, and people are saying, what caused this? And you need to provide information about the attack and what you think has caused the failure. Lots of people are going to be exchanging information. They'll be going to be making guesses about what went wrong, and gradually out of that will emerge the truth. But what I'm concerned about here is that the SEC, in writing up this complaint, went deep into the company, and I think most people here have probably seen that one of the emails describing a conversation with a customer said, "Well, I just lied." We all remember that because it feels like a smoking gun. But that wasn't Tim Brown. That wasn't one of Tim Brown's reports. That was somebody who reported to somebody who reported to Tim Brown. And lots of people are in the position of sort of having folks 2, 3, 4 levels down who are exchanging information and exchanging emails. Many of the emails that the SEC quotes from never got to anybody who had decision-making authority in the company, and yet the SEC is treating them as telling us what the company thinks about this topic. So I think if you're going to protect yourself against having your subordinates or some other executive subordinates' words used against you, you need to create a much more disciplined process for making sure that everybody can stand behind anything that is actually reported. And that's going to make everybody much more cautious about allowing a lot of exchange of information informally, because they don't want to be held responsible for mistaken statements made in the course of the informal discussion.
Yeah, I think I might have come across my confusion here. The company, there's probably a difference between someone using the product and someone creating the product.
Yes.
So the bigger concern you have is someone, like in this case, Solarwinds creating the product, that they might be more hesitant to share information.
I think exactly that.
Okay.
Now, look, they're already a little hesitant to admit problems. And that was, I mean, look, no one thinks that Solarwinds did a great job of securing its software or of being candid with its customers about problems that it had. There were some problems there, but I think that to turn that into a securities violation it's a bit of a leap.
Mm-hmm. And then, and this probably is related to the second one. It said a regime that incentivized early, detailed public disclosure of vulnerability information. So you would be saying that you wouldn't want to put out these bulletins, these advisories, this sort of thing early?
You want it out as early as possible, as is consistent with it being true. And we've all recognized circumstances where you think it's been contained and it hasn't. Mm-hmm. Or you say, I don't know whether it's contained or not, and am I going to now say all of my customers are at risk when I don't actually know that all of my customers are at risk? So there is going to be a lot of judgment about how much you can disclose and how certain you are. And that, to my mind, that's the biggest problem, is that the SEC is creating an additional liability that hangs over your head as you're making those decisions. And what that liability is going to do is not produce better information, it's going to produce more caveats. And you're all going to get used to that. You're going to have to start doing two things. One, sticking to the facts and not getting beyond what the facts tell you, even though you're pretty sure you know where those facts lead. And then second, making sure that you don't make any generalizations without a caveat. Your job as CISOs is not to decide whether this is a material breach. You got lawyers for that. You got a CFO for that. Your job is to describe what happened and what you know and what you don't know about an incident. And even if you are tempted and asked, well, what does that mean and what could it mean, you're going to have to try to refrain from those kinds of determinations outside of your lane, because it will only get you in trouble. And you need to say, here's what I know, and that's what I'm telling you, and I'm not going to tell you things that I don't know are true, especially things that are outside of the technical area of what happened, what we know, and what we don't know about the intrusion.
And you talked about that lower level, or certainly not CISO level person putting that in writing or something like that, but they have a record of Tim Brown saying that the current state of security leaves us in a very vulnerable state for our critical assets.
Yes.
Are we going to see, or should we see, a lot more message discipline in terms of anything that will generate a record? And at what level do we need to worry about that?
So I fear that's the case. In fact, we're going to see two problems here. People are going to be reluctant to admit that there are security holes and to say so. And people are going to be reluctant to say they've been fixed. Because if you say they've been fixed and they haven't, even if it turns out that it was a one-off problem, the analysis the SEC gave us suggests that they're going to seize on every failure and say, well, you promised us no failures. And you know, if I could do an inspirational poster for every CISO's office, it would look like a James Bond movie, and it would say never again. No absolutes. Don't say we check all of our systems. We prevent all intrusions. We never have had a problem of this kind. Those are just words you should not use. Absolutes have no place in the discussion of security. And everything you say needs to come with a caveat that says that's not to say that we can't be defeated. We always run the risk of being defeated because our attackers sometimes are enormously sophisticated and have found ways to defeat even very strong security measures. And you just need to have that footnote in every promise you make. And the biggest problem that Tim Brown had is he wrote a security statement that was more aspirational than accurate. Much of what he said was pretty much true, but you could argue with a lot of it, and a few things were just plain wrong. They weren't doing penetration testing, and they said we're following a secure a software design lifecycle that actually does have pen testing built in. So some of the things he said were just wrong, and that's what the SEC focused on. But many of the things he said were fine, except the implication was we always do it. And it turned out there were a couple of circumstances where they didn't. They had account management and credential management, but they also allowed people to use their own devices to log onto the network and get admin privileges. And that was how the Chinese got in. And the SEC said, well, you weren't following good credential management principles, and you said you were. I think some of that stuff was just wrong. They were taking stuff and saying, well, that you implied that you always did it, and we found a failure. And the answer for that, for people who are saying, I don't want to go where Tim Brown is to make sure that when you state your security principles, you make them principles, you make them aspirations. You say, these are the things that we think should happen. These are the things we do and try to do, and principles we live up to when, to the extent of our ability, but we recognize that failures are part of life, and there could be failures here. And it sounds wishy-washy and sissified, but that's how you avoid getting sued. And so I think we're just going to see boatloads of that on the one hand. And then the other thing we're going to see is boatloads of people, of disclosures of intrusions that probably aren't the end of the world, and certainly aren't likely to be material. But why take a chance? What the SEC did is it said, that very first intrusion, when you started to say you were spooked and you had an uneasy feeling about it, that's when you should have made the disclosure. I think that's wrong, but now that the SEC has said it, if you're spooked by an intrusion, if you're worried about an intrusion, the easiest thing, the safest thing to do is to disclose it. And yes, it's not good for business to disclose this, but so many people are doing disclosures of that kind that the business impact is going to be less severe than it would have been but for this new panic over trying to get disclosures in front of the public.
One quick comment, and we have a minute or so left for one last question. The comment is, I think a lot of the people in the audience have either done or received security assessment reports. Those are going to become more interesting now. If you hire a third party to do a report and they come in and they give you a report with all these issues in them, you can't put it in, or if you put it in the drawer, that's at risk, because now you have been told, so you're going to have to address all these things. And I think
or at least you're going to have to generalize them.
Well, you're going to have to respond to them in some way. You can't just ignore them.
And I think it's going to end up in your annual report to say we do these things and we find problems and we found problems of this kind, or try to abstract them to a level where people can understand them and it doesn't take up 20 pages, and do a fair disclosure of the kinds of problems people are finding. But I think there are going to be so many disclosures like that the likelihood that folks are going to say, I read your 10K and I can't believe I'm buying your product, is relatively modest. Yeah.
Well, and then the last thing, and if you could, a quick answer on this, almost a devil's advocate sort of thing. Isn't this the SEC's job? Like, they are supposed to, anytime something is said publicly that differs from the known reality inside the company, that in every other area that would be called securities fraud at some level. Isn't this their job to do this?
That is fair. I think, you know, the reason it was perceived as unfair is the security statement was never part of the securities statements. It was just, this is what we're trying to do from the point of view of computer security. Now it is linked, and nobody should kid themselves. If you say something about the security in your company, that is something that the SEC is going to enforce the accuracy of, and you're going to have to be able to justify it by pointing to what you did to make sure it was true.
Great. Thank you very much again for coming, Stewart. Thanks.
All right.